but given the nature of the transactions that are happening today, this is going to be expected, and I think what needs to be looked into is how prepared are you going to be so that you can be able to actually have your matter heard the way you want it to have without having the need and the consultation.
Okay. Thank you, Emmanuel. From what I hear you say, where parties are agreed, either by virtue of the rules or the institutions, they've chosen to administer the arbitration, where there are multiple parties, and it does provide for joining. I'll be happy to hear from any of the other speakers. What would you say the position is? Because that's the whole idea. The idea that on the one hand you have the multi-party arbitrations, right? And on the other, the issue of party autonomy. So from what I hear you say, with consent of the parties, then, the autonomy of the parties has been maintained, isn't it? Yes. So where that is withheld for even wrong reasons, what would you say the situation?
Assuming it's not in the national arbitration legislation, which usually it's not, there won't be any joinder or consolidation. So I think that the best you could hope for, and which was also like, you can also have it in institutional arbitration where consolidation per se doesn't apply, is to have a de facto consolidation to save cost and time, meaning, strictly speaking, you will have two cases, but the cases will run, you file a pleading at the same time, you'll have one hearing, so it'll be a way to basically do a consolidation without doing a formal legal one, because you cannot, the rules, the laws do not provide for it.
Okay, so what are the other, there are one or two other challenges that have been raised?
So we have to take one, which hopefully is becoming less so because the rules, most arbitrations have addressed it. Initially, the issue, joinder and consolidation can result in a situation where parties join or the arbitration is consolidated after a tribunal has been constituted, meaning a party is in a situation where it doesn't participate, doesn't nominate an arbitrator, doesn't have a role in the constitution of the tribunal. There's been a landmark case now 20 years ago, over 20 years ago in France by the French Court of Cassation, but which had really an impact beyond France, where it was a multi-party arbitration. Two co-respondents appointed one arbitrator under protest, basically arguing it's again my right to nominate an arbitrator to have to do it jointly with another party. They lost the arbitration, and then there was a set-aside proceeding, and ultimately the French Court of Cassation annulled the award, finding that the joint imposing the joint nomination, basically depriving a party of its right to nominate an arbitrator, was a breach of party equality, because the other party, the claimant, had nominated its arbitrator, and was against public policy. So after that, the arbitration rules now address the question of appointment of arbitrators in a multi-party joinder consolidation situation. They have done so in two ways. One is to provide the institution with the power to revoke the nomination of arbitrators already, the appointment of arbitrators already appointed at the time of joinder and consolidation. Or providing the parties, basically by choosing the rules, where they're right to nominate an arbitrator or participate in the nomination of the tribunal. So these are ways where basically the institution provide for this either like possibility, not obligation of the institution to basically revoke the arbitrators and have equality of the parties in the process, or in any way the parties have waived their right.
Thank you very much. Awesome. So clearly, where parties either have contractually agreed on any of these tools, or have subjected themselves, agreed directly in the contracts, or indirectly, yes.
That's right. When you ask that question about the challenges, I just wanted to say that you talk about challenge of consent. Some party may have some confidential information that you do not want to share with another party, and that could be against them from wanting it. Or there are also cases which I've seen where a party, just for the sake of delaying the proceedings or not wanting the real facts to come out, will avoid consolidation, even where they know that having consolidation will be more cost effective. They know the issues are related. They know it's the same subject matter, but they want to delay and prolong the matter, so they would avoid it. And then I wanted to add that, well, arbitration is evolving. And the nature, I mean, we all know it's a traditional means of resolving disputes in Africa, but it's moving beyond the rudimentary form it used to be. And we must appreciate the arbitral institutions, but because they're always on top of it. Okay, when you hear that ICC has amended its rules, LCI has amended its rules, it's not for the sake of amending rules, it's because they've seen something. Now, the case Elodie mentioned, you can even see the effect in the newer rules. For instance, I want to refer to the ICC rules. In their 2017 rules, no additional party can be joined after the confirmation or appointment of any arbitrator unless the consent of one party, including the additional party, is obtained. But then they started saying that even in cases where they wanted to do this, because they considered otherwise, their decisions. So what they did in the 2021 is that they gave more power to the discretion to arbitral tribunals to be able to do this, but still within a given framework. And so therefore, in 2021 rules, what it states is that any request for joinder made after the confirmation or appointment of any arbitrator shall be decided by the arbitral tribunal once constituted and shall be subject to the additional party having accepted the constitution of the arbitral tribunal. So you cannot now accept it and then go and say, at the end of the day, when he loses, that he didn't take part in the process. And that additional party must have agreed to the terms of reference where applicable. So you see how the arbitration rules are evolving and changing.
I think now like we see that in Asia, KIAC have similar provisions on possibility to revoke the existing appointment of arbitrators, and then the procedure then is the co-respondent or co-claimant appoint jointly. They cannot agree, this is quite interesting when they align, they cannot agree, then the institution will appoint all three members of the tournament. And again, the language of the waiver, so covering the ground to avoid a challenge. Consolidation and joinder, which is becoming more common to be tested before national courts, but the institution of the side and done are quite aligned in, I mean, like identify the loopholes along the way in their successive rules and addressing them.
Okay, great. So clearly, Mr. Michael said, the institutions are pretty forward-looking when they react proactively to the decisions of the court. Now, Emmanuel, I would like you to share with us what you consider the advantages of these processes of joinder and all that, considering, and this is speaking now from your experience in Kigali, in Rwanda, so to speak, what the position is with the national law and, of course, the KIAC rules.
Thank you very much. In terms of the advantages or the benefits with the joinder and the consolidations, it actually saves time and it's and costs. Simply put, you can imagine if you're going to have a multiple, proceedings. So if they are consolidated, then that saves time and money. Of course, the other side of the coin, somebody will say, well, it can as well be expensive. Given the time it is going to take, given the complexity that now it brings up, but all in all, I would think that instead of having multiple proceedings, you would rather have one proceeding consolidated. And definitely, in terms of the award that is going to come out of that, is that you're going to, you're likely to have an award that is based on the facts from the different parties that have, from the different proceedings that have been consolidated. And you're going to have...
Is this, sorry, Emmanuel, is this provided for under the arbitration law of Rwanda?
Yes, what we have, in fact, in terms of the joinder on the consolidation, we don't actually have that in our Arbitration Act. But we have this clearly stipulated in the KIAC rules. The joinder, the consolidation, is maybe multi-party arbitration. So this is very, very clear. Now the issue would be what would happen. I think it is an issue that you brought up some a few minutes ago. Is what would happen if there is an ad hoc, which is probably not what we are looking at here. What would happen in case of an ad hoc, and you cannot consolidate it because it's not provided in any other legislation that you have. Probably my colleagues who are here might have.
And expanding the scope of Joinder.
Yeah, and that's because the rules provide for joinder.
Yes. Well, now they like in reaction to that case saying that you need express language on that. And a more recent case, it was also Singapore Court in 2010-21. There was an issue of under an arbitration under the LCIA rules 2014, which provided that a third party may only be joined if it consents in writing to be joined. And so the Singapore Court found that this language, the question was, there was no express agreement to be joined. So the issue was, does the arbitration agreement in the case constitute such a consent to be joined? And the arbitration agreement didn't have any consent on joinder. It was a generally worded arbitration agreement. And the Singapore Court, again, stressing the importance of consent, said that this language, a general arbitration agreement, without express language on joinder, was insufficient to fulfill the criteria, the requirement of consent in writing under the LCIA rules. So again, that one way or the other, they need to be consent to a joinder, whether the arbitration agreement, the rules, but there needs to be a consent. And generally, raising a dispute requiring consent or joinder or consolidation at the late stage, and you don't have it in the rules, you don't have it in the arbitration agreement, that just won't work.
Okay, so sorry, so when you refer to the LCIA rules, they have, I know they had some provision referring to it, but it did not provide that by adopting those rules, parties indirectly were consenting.
Yes.
The
provision in dispute was Article 22.1 of the 2014 LCIA rules, which says a third party may only be joined if it consents in writing. So the whole point was only in writing. So no additional language which would.
Mrs. Rhodes-Vivour, the new LCIA, please, the microphone.
The new LCIA rules has also made some amendments on consolidation, which is also forward.
It would amount to consent?
No, not necessarily. It's not as also straightforward. But I mean, more power has been given to the LCIA court. The new rules makes it possible for the tribunal, with the approval of the LCIA court, to order the consolidation of arbitration that are commenced under the same agreement or any particular either between the same disputing parties or arising out of the same transaction or series of related transactions, provided that no tribunal has yet been formed by the LCIA court for such other arbitrators or is already formed that such a tribunal has proposed for the same arbitrator. So there are still rules that you have to obey. Because that more power is being given to the courts, the ICC court, the LCIA court, there's more power being given to them so that we can really utilize these principles and stop making party autonomy the premise for arbitration to become an ineffective process.
Great. Okay, and then what would you say about court support? Now I'm talking about national courts.
Okay, for Nigeria, I don't believe there's any case. I do for arbitration cases on a regular basis. I don't think any cases have come to court yet on this issue.
And that's because the law also does not have any provisions on that.
Not necessarily. The law may not have, but a party can still test it. So I don't think it's necessarily because the law has that. Maybe it's all part of our developmental process. I don't know whether there's any Nigerian in the room that knows of any case. You know, it might be because of, but I know we're going to get there because we are beginning to see. I'm beginning to see it. You know, and we're beginning to see it. So we try, and then our laws. Yeah, our laws. I mean, the old institutional model law. I don't believe it had provisions on it, but the old institutional arbitration rules 2010, they made changes. We have the Lagos Court of Arbitration law, which contains provisions on multi-party jointer. We also have the new Arbitration Act that we're expecting our president to assent to. So time will begin to see it. But the cases I got from other jurisdictions, and I think India is doing very well, because there are about 3 cases I got from India. I don't know whether I can still.
Yes, please. Yes, please. We have a couple of
there was a particular case, Naga Telefoniga versus Canara Bank. It was a 2019 case. And then the Supreme Court of India took a pro-arbitration approach. It was this issue relating, there was an arbitration clause signed by a company that was a group of companies. Right. One party was trying to say there was no arbitration clause. But the Supreme Court took a pro-arbitration approach and held that on the basis of the group of companies doctrine, where the conduct of the parties evidences a clear intention of the parties to bind both the signatory as well as the non-signatory parties. So we've moved beyond this, where that was what they did in that case. The courts and tribunals in India have invoked this doctrine, this group of companies doctrine, to join a non-signatory member of the group if they are satisfied that the non-signatory company was by reference to the common intention of the parties, a necessary party to the contract. And you know that's what we see in court. You can go to court and show that somebody is a necessary party. Then you, so arbitration is not that simple, and he's still trying to work within what we have. Then there was this other case, was an American case. It was 6 card. Can I go on?
Yes, please. Yes, please. We have we've not used up our 40 minutes.
Okay. It involves 6 car dealers. They failed to make payments under their profit sharing agreements. The car dealers filed a demand for consolidated arbitration because each of them had the same PSA with the other party dimension. The arbitration panel held that the claims of the 6 car dealers would be consolidated for purposes of discovery and motion practice. The panel reasoned that arbitration provisions in the PSCs granted the panel broad approval as they stated. The arbitrators need to, and this is interesting, going back to the flexibility of arbitration, which our courts have accepted, while even our Nigerian courts as well. The arbitrators need not observe judicial formality or strict rules of evidence, and they shall make their work from a standpoint of practical business practices. So is it standard business practice for you to have 20 bills of lading relating to one charter party and then to have 20 arbitration proceedings? This is a proper, furthermore, the panel held that it's a proper case for consolidated discovery and motion based in part on the principle that arbitration is intended to be an efficient, timely, and cost-effective alternative to litigation. Thereafter, the candidates moved to affirm their award, and then the other party dimension that didn't want consolidation, they moved to have their award vacated on the ground that the panel exceeded its authority by permitting the consolidation. The trial court rejected their argument and confirmed their award because they took it from a businessman point of view. This is the arbitration we're talking about. Yeah, and yes, and that was it. And so that was it. And then they said that the contracts were identical, and the offenses were likely identical. You know, so they held that view that, I mean, consolidation was in order. Then the final case I'll just mention is it's also an Indian case. I think it's India. Global Infonet versus Lenovo and other CS. Global Infonet had entered into 3 separate distribution agreements with Lenovo and 2 other parties. Global subsequently filed a suit seeking damages on the ground that the counterparties are colluding to undermine its business. The defendants filed separate applications seeking to refer the dispute to arbitration. All the 3 distribution agreements have 3 separate arbitration clauses. However, the Delhi, India again, however, the Delhi High Court observed that all the 3 arbitration agreements were part of 3 underlying distribution agreements which made up a single economic transaction between multiple parties. The court took a pro-arbitration approach and affirmed the intention of the parties to arbitrate. Consequently, following the settled law, the court rejected the objections that an application for reference to arbitration could not be filed in suit, which had parties which were not signatories to all the arbitration agreements, and the court effectively consolidated potentially 3 arbitration proceedings into a single one. So you can see the whole arbitration approach that's been taken by the courts. That's interesting. But you must have the material to be able to that pro-arbitration approach. You can't just think of it out of the courts. And we cannot undermine party autonomy either. So it's a clever balancing act.
Balancing act, yes. I think that's important. We'll be happy to take questions from the audience. Yes, please.
As well as another Indian case by the Supreme Court also, where this time it wasn't the group of company doctrine that was applied, it was the lifting the veil doctrine that was applied. And so the CEO of the company was joined to the arbitration. And so the CEO of the company was joined to the arbitration on the basis that he had sufficient interaction with that transaction for them to justify a lifting of the veil. My problem though is, how does this interface, or how does this play out in the context of sanctity of arbitration agreements and sanctity of contracts in general? Because we're talking about legal entities, irrespective of the arguments that were made in those 2 matters by the Supreme Court, which is that they were a single financial entity in essence, and in the other case that there was an individual who needed to actually answer to the case that was before the tribunal. But how does this play in the face of the sanctity of the arbitration agreement? Because these are parties that have not signed the arbitration agreement, and in fact, for all intents and purposes, they don't negotiate it, nothing. How does that? Yes, did not give their consent. Yes, they were objecting parties. So how does this play out in the context of the sanctity of agreements? Cannot proceed against a party against whom who is proper or necessary in litigation. The only issue is that
The courts, right?
yeah, but the courts.
The courts did that.
Yes, because the Supreme Court has been there.
Okay, yeah, it's the Supreme Court. The same thing that they was applying the same principle that this is business. Let us leave the veil, like it's even in company law, decided lifting the veil. Lifting the veil was not from the beginning, but later on they started saying that they had to leave the veil to prevent injustice, to prevent somebody getting away with fraud. So we need to know the particular circumstances of that case as regards to why they came to that decision. Because I'm sure there will be some other instances where they will not come to that decision.
Sorry, may I very quickly clarify?
Was a party to the arbitration agreement, but the other one was not. And the court sent them
Yes, the group of companies
exactly
was applied. Yes,
in referring them to the arbitration.
Lifting of the veil.
Yes, and in the other one, the Supreme Court said that this party could rightly be made a party to the arbitration.
So it was the court that...
No, yes, it was the court, not the tribunal.
Yeah, because
yes.
it's similar to a party who desires... okay, but that's Joinder now, not calling a witness.
Yeah, exactly.
But in that case, the court also refers to clear intention of the parties.
No, and intention is all fine and good. Like I said, these are sound legal arguments, and we apply them in litigation in court all the time. But this is a referral to arbitration, which is supposed to have been an agreement between parties to adopt this method of dispute resolution. And it just seems to me like if the party has not adopted it and objects to it, I'm not sure how it's played, how enforceable will be appropriate.
Ultimately, they are.
Yeah, and that's a good suggestion, because I thought about that as well. And I did check. Unfortunately, I don't practice in India, so I don't know whether at the time, I couldn't find whether at the time the local laws in India permitted arbitration between, or implied contracts, basically, in terms of arbitration, because some laws said, parties can consent impliedly to arbitration. So it may be that.
By the action.
Yeah.
So a clear intention. Sorry, the court in this case said a clear intention. So the court must have reasoned it out. What gives the court that indication that there was a clear intention of the party that they were going to be bound like this?
No, we're talking about the CEO now, isn't it? The lifting
No,
of-
he's talking about the group
Oh,
of
the group of companies.
Yes,
Okay,
yes.
yes, that sometimes can be unfair. Now she gave a detailed
Yes.
discussion on that earlier,
Yes,
that
yes.
you can infer that from the provisions of the related contract. True. It's the issue of the lifting of the veil. Yes. Anyway, it's interesting. I know Dr. Oye.
Grounds and the basis for lifting the corporate veil was not fulfilled. And so Lord Sumpton then used trust. And why is that an interesting case is because we were so sure, someone like me was so sure that there is no way. I mean, you need this basic company law. You can't do this. But that, I think we need to recognize that. But again, that is within the domain of courts. And so we can't always do this thing of if courts can do it, arbitrators can do it. And we did do, so the Nigerian Arbitration and Conciliation Act, for example, has an extended definition of party, additional party. And the key question then becomes, what does that mean? Because that's in the model law as an additional party, so there's an extension to who the party to the arbitration agreement is. But it's not rocket science. You have to be claiming under or through a party to be an additional party. You can't just pull in somebody from out of the street and make them a party to your transaction, and if they do not wish to be joined to that transaction. And then the point about having the judgment, and then you're able to enforce a judgment against a non-party, is difficult. How does that arise when we have estoppel? How would that arise? If I was not a party to this judgment, I did not participate. Why? In the UK, maybe if we have the Contracted Parties Rights Act, where a third party can benefit from that contract. But we don't have the equivalent in Nigeria. So how do you get a judgment and then you can then allow a third party to enforce? It might be possible, Jimmy is here, Jimmy Kodo, my authority on anything on Okoda law, but it might be possible under the Okoda Arbitration Act, which says that a third party that has an interest in that arbitration can follow through. There's a way it's worded in the new Okoda Uniform Arbitration Act. But that's because the law gives you that right. Apologies, I
Thank
talked
you
too
very
long.
much for that clarification. I think something is clear. Is cautiously ask my panelists if they have a last minute word for the room, 1 minute each, and we still will be within time.
I think they appreciate the requirement of autonomy. What the institutions are just trying to do is to allow themselves more discretion, but also within the rules. It's not applied.
Yeah.
So we shouldn't get carried away that it's applied. That nonsense, multi-party, that's so simple. You can just come and you can join because you have the same transaction. No. They have also laid down certain guidelines. There are certain conditions that must be met. It's just that they are moving with times. God doesn't stay static. You have to move with times. And if you want arbitration to continue to be effective and efficient, we cannot dogmatically hold on to the old concepts that we've been used to. But the arbitral institutions, they are also very much aware of their obligations to ensure that party autonomy and consent is very important.
Thank you very much, Mr. Rhodes-Vivour. Elodie?
Well, I mean, not much as very well said. I think that probably joiner consolidation has been one of the areas where there's been most development in the arbitration rules, like refining them, like kind of like learning along the way from what was an issue and getting to a very good place now. But it's also one of the most difficult questions in practice when you think about joiner consolidation for cases. It's not like any multi-contract situation would require it, but it's a tool. And if you have like a complex transaction like what described, multi-party, multi-contract, it's why it's wise when you enter into the transaction to give some thought to the arbitration, of course, but to the advanced and to clarification. Because it's complicated, and again, you don't want to end up in a Sanders-like situation. So you really have to work to preserve concern and to give some thought and be very careful about it.
Thank you very much. And to
seeing the judgments or the case law that we have heard about